Let's say you and your spouse have a very simple will. We sometimes call it an I love you will. What that means is everything goes to your spouse when you die, and because you want things to be very simple. And then what happens? Well, let's say you and your spouse get a divorce. Well, your will says everything goes to that divorced spouse, right? Well, if you live in the state of Washington, I have good news for you. We have a statute here that says if you divorce somebody, and if your will says everything went to that somebody, your ex-spouse, the state of Washington knows you probably didn't want that to happen. And so under our laws in Washington, what it says is we will treat that ex-spouse as having predeceased you. In other words, they will not inherit under your will, even though you forgot to change your will. Now, don't think you're out of the woods, however. I want to mention your 401k. Your 401k, if it says it goes to that ex-spouse, the Washington statute is not going to save you. Your 401k will go to your ex-spouse. If you live in a community property state, your estate planning might be easier than if you live in a state where they don't recognize community property. So we are in Washington, we are in Idaho. When I say we, I mean ELG Estate Planning, and we help clients plan in these community property states. So when you're in a community property state, unless there's a good reason otherwise to assume differently, all of your property is considered to be community property. Now, there's a lot of exceptions to that. There's exceptions for prenuptial agreements. There's exceptions if it's a later in life marriage. When we do estate planning for our clients, we want to kind of remove all the uncertainties, and typically we prepare for them what's called a community property agreement or a property status agreement. They mean the same thing, and what is intended to do is to clarify everything's community property, or maybe all of this is community property except for, the family lake cabin that I inherited from mom, and that's my separate property. So it's a really good planning tool to make sure that everybody knows what's community and what's separate property. In a community property state, you still need a will, even if you have a property status or a community property agreement. So let's talk a little bit more about a community property agreement. There are different kinds. There are some community property agreements that say, on my death, everything goes to my spouse. That is to take the place of a will. And in fact, sometimes it's called a community property agreement is sometimes called a Washington will. Why? Because it takes the place of a will, and it says on one spouse's death, everything then becomes the assets of the surviving spouse outright in trust and without the need for probate. So sometimes having this type of community property agreement that says on my death everything goes to my spouse is a really good planning tool. It avoids the necessity of probate. There are different kinds of community property agreements. Some community property agreements are what I call a three-prong community property agreement. The main piece of that is on the person's death, everything goes to their spouse. So for a three-prong community property agreement, what it says is everything my spouse and I have is community. Its second prong says, and everything we ever get is community, even if it's an inheritance to one of the spouses, which typically is separate. So if you have a two-prong community property agreement, that second prong says everything that we get is community, no matter where it comes from. And then the third prong of a community property agreement would say, and on my death, everything goes to my spouse. That's all there is to it, without the necessity of a probate. So everything then is the spouse's. Three-prong community property agreements are not the type of community property agreements that we at ELG Estate Planning would normally use. Why is that? Because even if we want to avoid a probate, in our estate plans, we always ensure that there is an opportunity to protect assets if needed. So we typically use what's called a two-prong community property agreement. And what that says is everything that we have now is community, everything we ever get in the future is community, but it doesn't have that third prong. It doesn't say, on my death, everything goes to my spouse. Why do we do that? A couple of reasons. In our wills, we will include what's called an asset protection trust. An asset protection trust is there just in case it is needed. So let's say you have two perfectly healthy spouses and they have this two-prong community property agreement, and their will also says, hey, everything goes out right to my spouse unless my spouse needs asset protection. One of the spouses dies and the surviving spouse is in good health, they don't need any asset protection. So we use that two-prong community property agreement together with what the will says, everything goes out right, and we will avoid a probate because everything will go to the surviving spouse, but we also use what's called an affidavit of surviving spouse at the time of that death. No probate, just an affidavit. On the other hand, what if the situation is different? They were two healthy spouses, but they were both in a car accident. One of them died, and one of them, the surviving spouse, was left with extremely high care needs. Maybe they've lost the use of their limbs. Maybe they have a traumatic brain injury. They're just no longer independent. Well, we want to protect assets for that surviving spouse. We want to make sure that they will be able to use state benefits to pay for their care and not have to spend down all the money that they have and that their spouse had. So we will want there to be a probate in this case. That two-prong community property agreement does not interfere with probate and asset protection. The will of the couple said, each of them has the same will, and it says that everything goes outright to my spouse unless my personal representative sees that my spouse needs asset protection, in which event I want all the assets to go to the trust for the surviving spouse, the asset protection trust. So in the event of this car accident where one is killed and one is left in basically bad shape, what we will do is have a probate and have the deceased spouse's assets fund a trust, an asset protection trust for the surviving spouse through a probate process. So what a community property agreement can do is avoid probate, but not interfere with asset protection if needed, assuming you have the right kind of community property agreement and the right kind of will that has asset protection availability in it. Estate planning is not just your will. If you live in a community property state, you may think, I don't need any estate planning at all because everything we have is community property. Well, let's not talk about what happens on death. There may be a way to avoid a probate upon the death of the first spouse because you live in a community property jurisdiction, and that's good news. But what happens if your spouse becomes disabled and you're both alive? You're fine, but your spouse cannot conduct their own personal affairs. Well, you live in a community property state. You say, well, everything we have we own jointly. I can manage all the affairs for my spouse, right? Not necessarily. You likely will be able to be their voice for their medical care, at least their emergency medical care, because we have a statutory hierarchy that says you can. But how about your finances? Well, you're probably on joint bank accounts. So yeah, you can manage the joint bank accounts and you can pay the bills. How about the IRA or 401k? Nope, you have no authority, none, to change the beneficiary designation, to do anything with their accounts, even if it's community property. And the biggest surprise of all for most people who are married and when their spouse loses capacity is you can't sell your house. Why? Your spouse can't sign the document and you have no legal authority as a spouse, even though it's community property, to sell your house without that spouse's signature. So what happens? What do you need to do? Well, there needs to be a court-ordered guardianship. It's now called a conservatorship in Washington, and that is the state appointing a guardian for your spouse who becomes a ward of the state. Very invasive and intrusive for that well spouse. And why did this happen? Because the couple did not realize that even in a community property state, it is so important to have estate planning documents, especially the living documents, the durable powers of attorney.